Good afternoon and welcome to Virtual Face-to-Face. I'm Alex Lakowski, AVP of Communications. We have to honestly and aggressively attack the universities in this country. The professors are the enemy. Those are the words of then Senate candidate J.D. Vance in 2021 at the National Conservatism Conference. He was arguing that universities play an outsized and biased role in shaping American thought and perceptions of reality. And just a few years later, the struggle of ideas regarding universities and academic freedom has reached a full boil. But fights over academic freedom aren't new. The birth of our modern idea of academic freedom can be traced back to the 1890s and the Ross Affair at the Leland Stanford Junior University. Young economics professor Edward Ross, his writings about the free silver movement put him at odds with university co-founder Jane Stanford. She wanted him fired. The university's president held back, and when the axe did come down, Ross's colleagues were outraged, and many left with him. Over the next several decades, academic freedom became generally understood as freedom in the classroom to teach and outside the classroom to pursue knowledge and speak about it without unreasonable institutional or government interference. Academic freedom is not the law, and it's not synonymous with freedom of speech, but the two are closely related. Now, over the last few years, universities have been greatly tested by the clash of views on campuses and how that comports with students' rights. And just last month, a student group here at Carey Law invited Heritage Foundation President Kevin Roberts, the so-called architect of Project 2025, to a fireside chat with our own Professor Mark Graber. Many urged the school to cancel the event, but Dean Renée Hutchins Laurent told students, "The vigorous defense of free expression serves as a bedrock of our republic, even when that speech is odious, and even when the speaker is immovably set in their position." Of course, our incident pales compared to what's been happening on campuses all over the country since Hamas' 2023 invasion of Israel. Mostly pro-Palestinian groups have staged hundreds of protests against Israeli military actions in Gaza. And some of those protesters say they were mistreated. And some Jewish students complained their universities largely dismissed concerns about harassment imposed by tent encampments and threatening speech. In December of that year, the presidents of Harvard, MIT, and Penn appeared before a House committee and were asked this question: does calling for the genocide of Jews violate university rules on bullying and harassment? Well, it can be, depending on the context, responded then Harvard President Claudine Gay. The other two presidents answered pretty much the same way, maybe. A month later, Gay and Penn President Liz McGill were out, but the debate about the limits of free speech and the responsibility of universities to maintain safe and harassment-free environments continued. And just 9 days into office, President Trump signed an executive order outlining measures to combat anti-Semitism on campuses, which was quickly followed by a Department of Education announcement of investigations into protest-related Title VI complaints at 5 universities. After $400 million in Columbia University's federal grants were frozen in March, that university agreed to overhaul its disciplinary process, hire more police with arrest powers, and even to make some faculty changes, although they have not yet agreed to enter into a consent decree. The breakwater, at least for now, appears to be the nation's first university and largest recipient of federal grants, Harvard. An April 11th letter, the Department of Education and HHS issued Harvard 10 demands ostensibly aimed at curbing anti-Semitism, including instituting viewpoint diversity in admissions and hiring, changes to a dozen programs in schools, and shuttering all DEI activities under any name. Harvard refused, of course, triggering a freeze of over $2 billion in grants. A few days later, the university asked a federal judge to declare that freeze unconstitutional on several grounds, including violating the First Amendment. The trade-off put to Harvard and other universities is clear. The complaint said allow the government to micromanage your academic institution or jeopardize the institution's ability to pursue medical breakthroughs, scientific discoveries, and innovative solutions. By the next morning, the school was joined by 150 other institutions, including this one, in a letter speaking out against what the letter calls unprecedented government overreach and political interference now endangering American higher education. The letter indicates acceptance of legitimate government oversight while asserting the essential freedom to determine on academic grounds whom to admit and what is taught, how and by whom. In other words, academic freedom. Joining us now to explain everything are two great minds from the University of Maryland Francis King Carey School of Law. Dean and Professor Renée Hutchins Laurent, and University System of Maryland Regents Professor Mark Graber. Later in the program, you'll have a chance to ask your own questions. Please write them in the Q&A area whenever you'd like. You don't have to wait. When it's your turn, I'll call on you by name. So please remember, you have to unmute so we can hear you. Now, please welcome your host, UMB President, Dr. Bruce Jarrell.
Thank you, Alex, and greetings to all of you. Another interesting session, and you notice that Alex had two great minds on this topic because, of course, I'm a fish out of water when it comes to this kind of discussion, but it's immensely stimulating, and I've learned a lot over the last year and a half in terms of what it means to interact with all of these different principles. So I want to thank Mark and Renée for being here. And look forward to the discussion. Now, one of the things that I'm finding extremely challenging in this position is keeping up with the daily flow of what happened today. And as you know, we have a whole team together that's trying to help us keep up with the many topics. And yes, you guessed it, another thing happened in the last day or so related to Indiana University. So maybe as a starting point, I'd like to ask Dean Laurent to comment about what happened at Indiana University and then have Professor Graber comment on it. So Renée?
Sure, happy to do it. So hello, everybody. Alex said that Mark and I are going to talk about everything. I don't know that I have the answer to everything, but we have the answers with regard to some things. So what is going on in Indiana is the state legislature has exerted control over the state institutions. So in a budget bill, they attached a rider to the budget bill that gives the state legislature control over the Board of Regents, complete control over the Board of Regents for the state universities, imposes so-called productivity quotas on tenured faculty. So increases the ability of the legislature to dismiss tenured faculty. Tenured faculty normally enjoy pretty extensive protections from dismissal to protect things like academic freedom. And also eliminated significant portions of the faculty governance provisions. So that's what happened. Part of the pushback is because there was very little notice, right? So there was a budget bill that was kind of working its way through the state legislature, and this rider gets attached with no discussion, no argument, no feedback. The leaders at the institutions were really blindsided by it.
And that's a public institution, I guess I would make sure to point out.
Yes.
Professor Graber?
Well, I think what this illustrates is a bit of death by a thousand cuts, or something a colleague of mine, Kim Shepley, once called the Frankenstate. What you do is you institute reforms that, standing alone and in different circumstances, might be innocuous. You say tenured faculty have to produce something. I don't think in the abstract Dean Laurent would disagree with that proposition. Our Board of Regents are always politically constructed. The crucial thing is, does the Board of Regents defer to, say, university and faculty judgments on tenure, treating their appointment as largely symbolic, or do they get into the act? Again, we can debate exactly what faculty governance is. If the governance is over the football team, okay, we get rid of it. I don't feel too bad. If the governance is over what the mandatory curriculum is, now that's a different issue. So in Indiana, we have a first strike, but it's unclear what it means. It could actually mean some things that are not particularly troublesome. More likely, it's the second and third strikes after this. But the idea is, because the first strike is, you can say you can live with it or not live with it. It gives a beachhead to better construct second and third strikes, which will be more consequential.
Right.
And for the audience, I would add that our regents are appointed by the governor. At the same time, my opinion is that they are very engaged in a proper way and focused on governance, not management. And so they largely leave the autonomy of the universities alone as long as you're staying within a certain set of guidelines. So it's a little bit different, I guess, from Indiana, in which 5 of 9 regents were appointed by the governor. Now it's 9 of 9 appointed by the governor. And it sounds like management things are rising to the regents, whereas that might not be the case before.
Right.
So that's different from a place like Columbia or Harvard or Northwestern, where they're private institutions. And so any insights as to, here's a public institution. I think this is kind of, well, I won't say it's a first because Texas has had some similar kinds of things, but it's pretty close. It's getting close to home now, being a public university. Comments?
On the differences between the governance of a private institution, a public institution, or the differences on the impact of the threats?
Well, let's say both, but certainly private versus public.
Well, private institutions have much greater autonomy over governance matters. So they are subject broadly to the law, but not in the same way that the state institutions, as state actors, are bound by like constitutional provisions and the like.
You might understand the threat being different in private institutions. So in public institutions, what we worry about is people who are successful in politics and get the power success in politics merits will use that power to influence academic enterprises. If you look at the board of trustees at Dartmouth College, which is what I know because I was an undergraduate there, it's largely composed by some of the biggest donors, people who are economically successful. You worry about people with economic power using that power to sort of subvert educational institutions. So there's a similar problem of subversion, but it comes from different sources. And some mixing is going to be necessary because guess what? Universities need political support and universities need money.
Fascinating distinction. And one I wouldn't have thought of readily. So then we are sitting here watching Harvard, and I don't think we need to restate what's been happening at Harvard. Maybe a brief summary. I think Alex gave in his description of Harvard got a letter from the government, and Harvard has resisted that letter and said, no, we're not going to do that. So what has been your interpretation and what's your prediction about what's going to happen here?
Your prediction, Mark?
Okay, well, if I could give 2 background issues, but just to let people know, Alex, you've done a wonderful job on the general thing. There are 2 legal issues Harvard is arguing. The first I simply know of, though I don't have particular expertise and maybe somebody else does, which is that there are a certain set of procedures that the federal government must follow before making a finding that justifies freezing, suspending, getting rid of a grant. There is no evidence those procedures were followed. So there's a note saying you were very, very bad on anti-Semitism, but there is in fact no federal finding on this subject. The second is that while the government can condition funds on certain things, it's pretty obvious. If the government gives, say, our university funds to study cancer, we can't use those funds to study 19th century legal history, even though everybody thinks that's more important, or at least I do. But there needs to be, on constitutional law, a germaneness condition. So the government has every right that if they give our university funds to study cancer, that we use them to study cancer. The government has rights to say, you're going to study cancer and your labs must meet these conditions. What the government normally cannot do is give funds that go for one thing and then attach conditions that have nothing to do with the project, particularly when those conditions threaten constitutional rights. So government can't say we've built a road, but by the way, Jarrell, Laurent, Graber, and Letowski, you can only drive on the road if you agree not to criticize the government. Can't do that because it's not relevant to the reason governments build roads. It can say you can only drive on the road if you drive safely. Only drive on the road if you use a car that's relatively fuel efficient, but it can't buy up our constitutional rights as a condition for driving on the road.
Right. And I just want to drill down a little bit on what Mark is saying so that people who may be interested in how those claims are anchored in Harvard's complaint have some additional information. So you can think about Harvard's complaint as falling into two buckets. They're the buckets that Mark just described, but to put labels on those buckets, you know, one bucket is a bucket of constitutional concerns and the other bucket is a bucket of statutory concerns or concerns that are grounded in laws that are passed by Congress as opposed to the Constitution, right? That's the distinction. And so in the constitutional bucket, Harvard is alleging both First Amendment and due process claims. And in the statutory bucket, Harvard is alleging both APA and Title VI claims. And so to drill down in that a little bit further, right? Like with regard to the First Amendment claims, Harvard's challenge is that the freezing of the money amounts to an unconstitutional attempt to control academic decisions that are being made by Harvard. And in the due process attack on what Harvard's doing, on what the Trump administration is doing, Harvard is complaining that in clawing back that $2.2 billion, the Trump administration didn't give them notice or fair process, right? Those due process claims, that concern about notice and fair process, you're going to hear some of that echoed in the statutory bucket under the APA. So the APA is the Administrative Procedures Act, and it requires the government not to be arbitrary and capricious when it acts, which means that the government has to give some kind of notice and some kind of opportunity to comment, and and that it has to be tied to some rational goal of the government. And so the claims are similar, right? They're about process, but they're anchored in two different sources of law. One is anchored in the Constitution and the due process. The other is anchored in the APA and the procedures that it requires. And then the fourth challenge, right? The second prong in the statutory rights bucket is a Title VI concern about the impact of the cuts on minoritized students. And I think that's actually going to be a really interesting line of legal analysis to follow in light of, and I may be just talking to the lawyers in the room for a minute, but there was an executive order that came down talking about the Trump administration's desire to walk away from disparate impact analysis. And this Title VI claim is entirely anchored in disparate impact. So disparate impact is just like if I want to discriminate against somebody, but I don't say that I want to discriminate against them, you can look at the results of my conduct, and if the results of my conduct are showing discriminatory impact, you can somehow backdoor your way into a claim of discrimination that way.
It remains an interesting contrast to me. So the action that Harvard can take in respect to the federal government is contested in court. So what are the actions that the Indiana University system can take relative to the state's actions? A lot different situation.
They could sue.
Can you sue the state?
You can sue the state unless there's a provision that says a state agency can't sue the state.
Yeah, I have no
Yeah,
idea.
but it's not likely, as you point out, and this is why we call the Franken state. What you do is you imitate somebody else, but for different results. So on the trustees, Indiana goes, hey, Maryland, blue state, blue as can be. They got 9 trustees. Didn't hear Jarrell or Laurent complaining about that. We also have post-tenure review, and it's very hard. Faculty governance is a more complicated feature of academic freedom. With academic freedom normally consists of freedom to teach, freedom to research. To the extent they're getting rid of faculty governance on those matters, that's a serious problem,
Right.
and a First Amendment case can be made.
Right.
To the extent they're getting rid of faculty governance on some other aspects of the university, it's not clear that's covered by academic freedom. So nobody thinks, for example, that academic freedom means the faculty should have a say in the hiring or firing of the football coach. It's a matter of university governance, but it doesn't deal with the production and dissemination of knowledge, which is where academic freedom really matters.
Predictions on the Harvard case and predictions on the Indiana direction.
Nope.
Not a single one. I don't have predictions on Harvard. I mean, I think on the First Amendment and due process claims, I think they will probably win. Probably. But when it goes up to the court, when it goes up to the Supreme Court, I don't know. And on the APA and the Title VI, maybe they'll say, go back and redo it, right? Like give them a little bit of notice, give them a little bit of process. But once you do that, you're fine to strip the funding. So it may be a Pyrrhic victory. Like they may get their day in court. I honestly don't know. It's 6 of one, half dozen of the other. I've stopped trying to guess.
That's it. It's hard to predict these. Mark, can you hear us now?
Yep. My apologies. I took off the microphone. Is my sound okay?
Yeah.
Well, a little garbled, but it's fine.
A little garbled.
Yeah. Okay. I think it's one of those questions. If you had posed this as a hypothetical to a group of law professors and not specified the legislature or the government doing the conditions in the universities, it would be close to 9-0.
Right.
That this is too much. That it's very clear that what goes on in the Harvard Middle East Studies Department has nothing to do with what goes on in the cancer ward, that you can't use funding for cancer to influence Middle East studies.
Right.
Now, with this court, can you make confident predictions? I'm with Dean Laurent. Namely, if anyone gives me odds, that's the way I'll bet.
Gotcha. Alex, do we have questions?
We do have a few. We have an anonymous question that writes, there have been significant number of grants that are already awarded that have been canceled due to changes in priorities at NIH. Do any of the legal arguments being discussed for Harvard and the funding withheld also apply to cancellation of awarded grants at many universities?
Yes.
Yeah.
Yeah. So it's the process question, right? It's not the substantive question, it's the process question. Like, I don't think that anyone would dispute that the government can, within some guardrails, decide how to direct its funding. What it can't do is say you can have this thing and then just arbitrarily snatch it back because the administration changes. And so providing some process is generally required.
The real issue on many is you have to take a look at the terms of the grant. So unlike a lot of university grants, some grants to individuals a dissertation grant is subject to constant renewal. What cancellation of a grant really is that while everyone thought, yeah, this will go on for 5 years, no, the government isn't renewing. The other problem is $2.2 billion worth of grants. That's worth hiring a lawyer. That even if you pay the lawyer a lot of money, if you win, you're better off. A graduate student with a $15,000 grant and a very complicated legal case is not in a great position to hire a lawyer at $500 an hour, because even if they win, they lose.
And I think there's a difference, right, between an approved grant that the funding just isn't flowing anymore, right? And the renewal of a grant that you were just sort of assuming would be renewed because it's always been renewed.
Yeah. So,
Correct.
so I think all of our grants here are awarded to the institution. I don't know that we get any individual awards unless the two of you have an awareness of that.
You mean individual, like to a person?
No, all the grants here come to the university, with the few exceptions of the foundation where there's not profit rules. So pretty much it's not to individuals, it's assigned to individuals, but the award is still to the university, and we're responsible for the compliance and the execution and the accounting and all of that.
All right, I want to bring in Lauren Schuyler. She's got a great question, but it's a long one, and so she's going to have to ask us herself. Lauren, are you there?
Yes, I am. Can you hear me okay?
Yes, go ahead. Mhm.
Yeah, okay. So the reason it's long is I just needed to give some context. So my research team, we're a bit of an anomaly on campus. We largely conduct policy and program evaluation on anti-poverty programs. And right, it's well established that poverty has structural causes, right? And they disproportionately help or harm program participants. So none of our research staff, even PhDs, are classified as faculty. So it's unclear the extent to which academic freedom applies, even though we are conducting research here at the university. So we are struggling right now with being true to our work and true to the results of the studies that we're conducting related to these programs and policies in the current climate. And we haven't received school level guidance, despite asking about how to proceed, but we've been unofficially told to avoid certain constructs and words that are important to explaining our work. So I guess my question is, should we be rightly worried about what we are writing and making public? And can we expect any guidance to come from the institution or schools in the near future?
You want me to take the first?
Yeah.
Bruce, do you want to take that at an institutional level?
Well, it's a difficult question to ask because, you do threaten your funding. If you saw that the National Science Foundation had a list of 30 or 40 words that automatically triaged a grant. We're clearly seeing grants that are being terminated because they deal with DEI types of efforts. So, you've kind of got to balance things. Do I want to keep the grant and do the work? Or do I want to have my words censored to say I can't use certain words? So Lauren, I don't have a precise answer to you. I think it's a case-by-case basis. The approach that we've been taking is the work is still the same. It's still important work for us to do. We just need to be careful about our language. I don't like that answer one bit. But on the other hand, there's a practical part of the work is important. And if I wanted to move forward, I've got to figure out a way to do that. Not a sufficient answer, but I'm open to better answers. Mark or Renee?
Well, I do want to clarify one thing that you just said, President Jarrell, because I'm channeling Elena right now, and so I know that what you are not saying is we are going to violate the law and just name it a different thing, right? Like what you are saying is we will comply with existing law, and to the extent that that there are particular words that are getting flagged in these sort of nonsensical ways, that changing the language to not get flagged in these nonsensical ways makes perfect sense. But the substantive work that we are doing is work that is going to comply with all federal and state rules.
Well, I agree with that, but at the same time, Lauren's talking about a grant that she received, which had all of the activities that they were planning to do in this grant well described and approved by the granting agency. And so to me, it's not an issue of being secretive or working around or being outside the law. It's here's
Right.
what you said you were going to do to execute the grant. It's different for university programs that focus on the needs of certain groups here. And we know there's a legal and a not legal way to do that. And I totally agree that we will do it the legal way. On an individual grant, it seems to me it's a little bit different in terms of where you end up. This is an approved process type of thing. Mark, any other comments?
Just on a slightly different angle of what she said, that you are or are not faculty is not relevant for academic freedom.
Right.
Academic freedom concerns the research and teaching done at the university. If the university gets a grant, again, we'll just use a cancer grant, and decides some local doctors in town would be really good to administer that grant, and they pay them and they don't give them a title, that research is subject to the principles of academic freedom. So assuming, as you describe it, that you are engaged in university-sponsored research within the aegis of the University of Maryland, Baltimore, the principles of academic freedom govern your case, which means, among other things, they need to follow the law if they want to get rid of your funding. They can't insist as a condition of the funding you stand on your head an hour every day or do other things that are non-germane.
We have an audience member who wants to dig a little deeper into this sort of area of the issue. And he or she is quoting the recent Notice of Civil Rights Term and Condition of Award memo that says that if you're going to get an NIH grant, you certify that you will not, during the term of the financial assistance award, operate any program that advances or promotes DEI, DEIA, or discriminatory equity ideology in violation of federal anti-discrimination laws. And of course, this has sparked a lot of grammar policing on our end, but we don't have to get into that. But this has been the subject of a lot of discussion, and the questioner wants to know what should we take from that?
So I am going to get a little bit into the grammar because I think it's so deeply interesting. But my top line answer is that the language in violation of federal anti-discrimination laws has to apply to all three things.
Right. I'm with you on that one.
Because to read it not to apply to all three things would make the language patently unconstitutional. And so what they are talking about is you cannot administer your programs in a way that violates the law. Like in some sense, this isn't saying anything other than follow the law. That's it, which we do. And so I don't think that people should get too worked up about this language. If they are already conducting the work that they are doing, even if it is DEI, DEIA, or discriminatory equity work, that they shouldn't be concerned about it if they're doing that work in a way that complies with the law.
We've had long and deep discussions about this.
It's the Oxford comma.
And I learned about the Oxford comma and all that kind of thing. I think the reassurance that I would give you is that our general counsel has had extensive conversations with the Attorney General's office in terms of the interpretation, and we will certainly have as part of our official documents that is our interpretation of this particular executive action, and that therefore you will have your attestation in that form. Exactly how we execute that, I don't think we've finalized that, but I think we're on pretty solid ground of agreement on how we're going to proceed about that. So as Dean Laurent says, I don't think you should worry about that. We're going to try to have things in place that say, here's our interpretation. And as a corollary, of course, we're going to do it in a legal manner, et cetera. And one other thing that I thought Renée was going to say, but I want to say, and that is that in stating this word about language and everything, this isn't just about making sure that we do or don't use certain words. It's also about that we're not trying to be obstructionist. We want to be legal in what we do, and we want to be inclusive of all members of this campus and these various activities. So there's no intent here to mislead. We want to be within the law. And as far as we're concerned, we have been and continue to be within the law.
Right.
Renée, you've been in the middle of those discussions.
I have.
Any other comments?
No, I think that's exactly right. I think that the work that this institution does that aligns with its core values and with its mission is important work, and we shouldn't be leaning away from that work in this moment. We should be leaning into that work. It is absolutely essential that we are doing things that are promoting health and justice and erasing discrimination and inequity that is anchored in historic discrimination. It's important that we continue to do that work.
Just to
You
add,
have to. I'm sorry. Go ahead, Mark.
presumably we can teach the 14th Amendment, though if you read this literally, well, the 14th Amendment says we're not a white man's government. In other words,
Right.
we have to teach diversity.
Right.
It says no state shall deny to any person the equal protection of the laws. We have to teach equity.
Right.
It says all persons born or naturalized in the United States are citizens of the United States. We have to teach inclusion. So it's clear we have to have practices that respect diversity, equity, and inclusion. The Constitution, the law of the nation demands it. So the only thing we can't do to make any sense of this is exactly what Dean Laurent said. We can't behave illegally, but we can do whatever we think best to realize the promise of the post-Civil War amendments as interpreted by the federal judiciary.
I love how you always make it clear, Mark. And I haven't heard it said that way, and it just is very crystallizing to me, very crystal clear.
But you have to allow, I would say, that this kind of language would have a chilling effect. That, your average person says, well, you can say that I'm acting within the law, but what if the authorities say I'm not, and they shut down my grant, and maybe a couple of years from now I can get it sorted out, but it's kind of scary, isn't it?
Chilling.
Yeah, that's the point.
Right.
Okay. All right, the big question. Karen Russ. Karen, go ahead and ask your question.
Well, hello, everyone. Thank you for holding this really important discussion today. I'm really interested to hear the particulars that you presented, and then I also wanted to ask a more far-reaching question in that many commentators say that we are currently in a constitutional crisis with the current administration ignoring court orders to overturn some of their edicts. So I'm just wondering, if you have any insight onto what may happen as the various branches of government come in conflict, I will say, and is there a pathway out for the country?
Luckily, we have 6 hours to talk
I
about
was
this.
going to say,
No, we don't.
East and unto itself.
So it is my view, and I am not a constitutional scholar, so Mark may have a different view on this. But it is my view that we actually we have crossed the Rubicon. We are in a moment of constitutional crisis. How do we dig our way out of it? That one is more complicated. The courts have to continue to hold the line. And then when you have three co-equal branches of government, what is supposed to happen when there is tension between two is the third is supposed to step in and enforce. That is not happening in this moment. And so I don't, Mark, maybe you have a better answer, but I don't know how we get out of this moment without the third branch of government stepping up.
I put in chat, and maybe Alice can send to everyone a piece I just wrote.
I will do that.
It's a blog post, so it may actually be readable. I was at a political science convention over the weekend, and the general thought was we are, as a country, drifting into something that's called competitive authoritarianism. It's where there still are elections. I'm not going to be arrested for what I say today, but the government uses a variety of levers, including the attacks on universities, to so tilt the political playing field that the government almost always wins. So what we're seeing is not simply, ignoring courts, but a willingness to challenge and in some sense partly subvert, though not completely subvert, any institution that might serve as an alternative source of constitutional understanding. So it's not even simply three branches. Universities, the media, all sorts of forms of private life are under attack and under great pressure to support the government. So even business, another item from today's news, Amazon, as a way of protesting Trump policies, is now adding, here's how much of the price we had to increase because of the tariff. They're being pressured by the government to take that down. Here is sort of government pressuring business to hold its line. And it's very dangerous when we all think as one. It makes universities, as President Jarrell well knows, really hard to run, but it's what universities are about. Professor Laurent doesn't have that problem. We just think alike at the law school.
The easiest job in the world.
Someone in the audience is asking, I wonder, is there a concern that UMB is going to be facing the types of direct threats to academic freedom, in the way that Harvard and Columbia are facing them? It's probably a question for you, Dr. Jarrell.
It's a hard one to answer. We are definitely facing the threats that have to do with research. We are definitely facing the same threats that have to do with international students. And we are definitely facing the threats that have to do with the term that doesn't exist, DEI, as a legal term, and we're clearly having to respond to that. I guess from a federal government point of view, it's less likely that we're going to see the kind of thing that Harvard is seeing, and we're more likely to see the thing that Indiana is going to see, although in this state, it's hard for me to believe that we would be in that position. But I don't have an answer, and Renee, you're shaking your head. What are your thoughts on that?
So I agree with that, and I think that if there is a way to find any glimmer of light in where we are currently, I do think that there is an opportunity for us to think about ways in which the current moment provide us with chances to do the work that we are doing more intentionally and better. Chances to reflect on things that we have long just assumed, and instead work to build into the work that we are doing bulwarks against government overreach that will allow us to do our work well into the future, right? Like, it's a way to think about future-proofing the institution, and in a state in which we are not subject to the same kind of acute attacks that my colleagues in some other states are experiencing. And so we could use this moment of crisis to push us to think about what it is we really want to accomplish, right? That's been sort of one of my complaints for a long time about the language of DEI, is that it's a shorthand, lazy way sometimes, right, for us to not really dig in and say, what are the outcomes that we want to accomplish by doing this work? And now let's build backward from those outcomes to figure out how to get there very intentionally. And I would love for us to take this moment to do more of that.
I think just since you used the word rethinking, I think rethinking how we become a resilient university, what are our priorities, and in having a list of priorities, we know that it's actually a list, which means there are things we won't continue to do and things we will do with great fervor. And of course, we've not been forced to do this. And the other thing I think I would add is, of course, one of the drivers is economics, isn't it? It's
Right.
not just politics. It's not just somebody else's opinion. We have the economic reality as well,
Right.
given the state situation and federal cuts. Mark, any comments on this?
I think this brings up a tension. On the one hand, we all agree we could do things better. We sometimes disagree on what would be better or how to do them, but it's been 30 years I've been in this system, and it's been a 30-year debate of how you can do things better. What the intervention of politics does is it creates a temptation, and a very real one, to sort of just go to the barricades, that if you concede, gee, this is something we could do better, suddenly at AHA, you risk having your funding taken away for normal things. So what I worry about is Trump is encouraging a very unhealthy circling of the wagons, but when you're under attack, you circle the wagons.
You were talking about the university being resilient. We have a very creative, if nothing else, audience. I want to bring in Lois Warner, who has an idea. Lois, what's your question?
Hi, good afternoon. Thank you so much for taking my question. If the United States government will not provide funding, can institutions of higher learning take funding from other countries for research and programs? I mean, we have the institutions, we have the equipment, we have the buildings, we have the manpower, we have the staff. What if, say, another country comes in and says, hey, we want research on this, we'll pay it, we give them the data.
A difficult topic, Lois, because I think what's happening with our federal government, and I guess it's mostly federal, is a lot of restrictions on that, and some of them rightly so. So there's a lot of scrutiny over interactions with other countries, and that's been counter to the way we've always viewed academic freedom and sharing of data. So I say there's a lot more restrictions to doing that. So right now, I think that would have its own set of treachery associated with it.
There's a related way of thinking about the problem. You presume the foreign money comes here. What we are seeing is people are going to the foreign money. For a long time, the United States was the beneficiary. Something happened in Hungary, and the 4 best cancer researchers in Hungary moved to a university in the United States. They tightened the budget in English, and suddenly a lot of English philosophy professors came here. What we are now seeing, and we're seeing it in law, we're seeing it in science, some of the best American researchers and scholars are moving abroad to do their work. In other words, the money, and that's where the money, maybe Canada can't fund the University of Maryland, but Canada can fund the University of Toronto.
Right.
And create, chairs for Maryland faculty who go to Toronto. And Renee is nodding because that's going to be a problem in years to come.
Yep.
Well, it's the reverse drain, a brain drain, and that we're now getting drained as opposed to draining. And there was just a survey that I saw that said that 3/4 of investigators in this particular survey had at least considered moving out of the US and the research in another country. So I think, Mark, what you say is exactly right. Bringing the foreign money to this country, a lot of rules around that, having investigators move to another country. It's an interesting approach, and I could see it happening.
I don't know if you have any way to, either of you, to answer this question, but one of our audience members asks, in light of DOJ layoffs and our resignations, what government legal resources are available to litigate or defend the federal government's position vis-a-vis executive orders and everything else? How does this really affect the capabilities of likely litigation outcomes? In other words, are they going to be so overwhelmed they can't properly litigate these cases? Or do they have infinite resources?
No, they don't have infinite resources. They do have about $1 billion in pro bono.
That feels infinite.
In pro bono representation from some private law firms. I say that in jest. Not that they have the pro bono, but that they could assign them to work on these cases. I say that in jest. But I don't think we have seen an impact yet on their ability to respond to lawsuits.
But one of the points there is, let's turn it away from the Department of Justice and put it into the NIH or other places that fund research. Even if we get grants reviewed by the NIH, will they have the machinery in order to make the money available and transfer it to us and follow all the rules about that? So it's a double-edged sword for sure.
Mm-hmm.
There's a different way of looking at Alex's problem that's, I think, very important with respect to the Department of Justice, and we're already seeing it. We tend to focus in law schools on the hot button issues, abortion, DEI. But in fact, much of what government does is prosecute bank robbers. What we are seeing is a brain drain from the Department of Justice, from some things we can pick up first. There aren't as many lawyers to prosecute bank robbers. The lawyers who are doing the prosecution are no longer as good or as experienced. And I think most important, one of the crucial features a lawyer has with a court is trust. That the lawyer does not misrepresent. What we're seeing is a number of prominent courts throughout the country saying, and conservatives on these courts saying, we no longer trust what the Trump Justice Department is telling us. And that's going to affect not simply the hot button issues we all worry about, but can the government prosecute the ordinary fraudster, the ordinary bank robber? That is a basic function that no matter what your ideological perspective, you think government ought to be doing.
Okay. Back to sort of First Amendment question and sort of the province of the executive branch. One of our audience members writes, can you speak about the case against Mahmoud Khalil as the Columbia University activist? The government is using a defense that Khalil's activism poses potentially serious foreign policy consequences. What are the merits of that argument in the context of one person on one college exercising free speech, that they could actually pose a serious foreign policy consequence?
Mark, I'll defer to you on the First Amendment issues. I think the bigger problem with the case is the evidence supporting the allegation. We haven't seen what that evidence is, and so that to me is the biggest question. Like, will they actually be able to sustain? I could, in theory, think of a person who might present significant threats to the foreign policy of the United States. I just don't know that they'll be able to make that case with regard to him.
I do think this could be a good examination question where we could cover about 5 courses. What is wrong with this effort? But it starts, and this is going to be a very crucial question for the courts. I want to move to immigration for a second, where what Trump is claiming, of the administration, is there's been an invasion of undocumented persons. No one in the history of the world has ever used invasion in that way before. Will the court, which normally defers to the executive on foreign policy, say, well, it's not what we thought was an invasion for 235 years, but if they say it's an invasion, it's an invasion. Same, there have always been protests on American foreign policy. Vietnam, the Civil War. No one was ever deported under the Alien Enemies Act. Before then, no one ever else thought a protest could damage the United States standing in the world, much less one person. But again, this is a court that defers to at least Republican presidents on foreign policy. It remains to be seen how deferential will be on this one.
And the other thing that I would note in that regard is that I think it's something we should be watching, right? So we have seen a contraction of rights happening. So in the Fourth Amendment space where I work and write, what we saw was the constriction of protection happening first at our borders, and then bleeding into the way Americans were policed, right? And so I think that we should be thinking carefully about, while in this moment, the language is all about undocumented people and immigrants, it is not a far jump to get to American citizens. So it does matter, even if it doesn't matter to you right now.
Alex, we got time for maybe one quick one?
Well, this is a little bit off topic, maybe, but we've touched on it. It's about funding. And I almost hesitate to ask you this one because you might have a visceral response, but we always talk about the economic impact of the university being so great, and our research has this huge impact. And someone writes, is it even a possibility that the state might help support research? State funding could be a greater option. Maybe in Maryland, maybe somewhere else. I don't know. But what do you think about that?
Well, let me take a stab at that. First of all, there has been some statements by the state to say they're not really into funding research. That's the federal government's responsibility. So I think that's a general attitude. Second of all, if you're talking about Maryland specifically, they're in certainly no shape to be doing that right now and for the foreseeable future. So although I would love to see that happen, and many would agree with me, it seems like that is an unlikely prospect right now. Renee or Mark, anything to add?
I agree 100% with that. I do think that diversification of revenue streams is going to be important to this institution's future proofing. But I just don't know that the state's in a position to be one of those diversified revenue streams now.
With a ditto, but one comment worth noting, one of the great strengths of the United States is a series of research universities scattered throughout the country whose findings are applicable throughout the country.
Right.
So one advantage of federal funding is if we discover something that helps cancer patients in Maryland, it doesn't stay in Maryland. Notice in theory, just as we can say foreign countries stay out, if universities start depending on state funding, maybe they can say, you know what, the first beneficiary of this has to be people within the states, and sorry, people in Delaware, fund your own university.
And of course, you're not stating it, but most research doesn't have a payoff next month. it takes a decade for these really significant discoveries to have a payoff. And a lot of times it never has a payoff in a direct manner, although there may be other spinoffs. So, well, Alex, I think we're out of time.
Yep.
For Mark and Renee, what a wonderful experience. And as I said last time, maybe I should go to law school, but maybe not. Maybe not. But I really appreciate the
We'll extend our application. We'll extend our season, right, Renee?
And we do have an online MSL. Just
Yeah.
put it out there.
Yes. And I know it's a good course because Dr. Ward took it and was
Exactly.
very laudatory. So, but thank you for being here with us today. A difficult topic for me, but obviously something the two of you are very facile in. So thank you for your comments. And for the audience, thank you for being here with us. Until then, see you next time.